Okay. Well, let's see if we can get through this today because this is set for final summary.
Retry.
Pre-trial. All right. Okay. I think the last place that we were at, Miss Norman, you were there though?
I am here, Your Honor.
Okay. The last place we were at is there were documents going back and forth. And the question is,
The judge immediately tries to regain control, referencing documents being passed around, but there's a noticeable lack of clarity between both sides. What should be a simple procedural step already feels disorganized, hinting that deeper issues are about to surface. The calm tone masks underlying tension as the court attempts to piece together who has what. It's a subtle but powerful opening, one that signals this case may not be as straightforward as it should be. Right away, the audience senses that something isn't lining up.
I stuck to her. Right. Miss Norman, did you receive that?
I did.
Okay. All right. So now everybody has what everybody else has, right? Yeah. I think you were able to open the one that Miss Norman sent. We got that done. And then what you sent in was it. All right. So, Ms. Norman, as to what was sent to you, do you have anything to say regarding that?
Well, reading through it it was a little confusing to me because he asked that the plaintiff's claims be denied, and he's the plaintiff. So I don't know.
Okay. If the parties are switched or the name on the party, then it makes sense to you. Or at least you may not agree with it, but it makes sense in terms of what's being said.
Yes.
Okay. All right. Um I guess, and Mr. Stanford, I'm gonna just ask this. Your court in looking at it believes that there was a what let me rephrase that, strike that out. Why do you believe that the resolution of the last case didn't resolve these issues?
Can you speak about?
Why do you believe that the resolution?
As the plaintiff explains his position, cracks begin to appear in the logic of his claims. He argues about damages discovered after the tenant moved out, but his explanation feels uncertain and slightly disjointed. The judge listens carefully, probing for clarity, while the timeline of events starts forming in front of us. There's already a sense that the argument lacks precision, and the more he talks, the more questions arise. This section quietly builds the foundation of doubt, setting the stage for deeper scrutiny ahead.
The resolution of the last case did not resolve these issues.
Because she still occupied the property. I had no idea what damages or condition the property was in until after she moved out. In that consent agreement, there was here. The second page on that had a line in there regarding there might be additional damages due to physical damages to the property.
When did she move out?
Oh, she moved out the day before the end of that agreement that we had come to. She was going to move out by before the 31st of October 2024, and she did that.
She did, right. She complied with that part. And then
So
just look, go ahead.
So November 1st, I went in and I did an inventory, and the pictures you saw that I've submitted to the court is what I saw when I walked in through the house on November 1st.
All right. So how much was her security deposit?
The security deposit that I was holding was, oh, I believe it was, around 1,020 or 1,050, I believe.
Okay. And so the entirety of the amount, is that all damages that you're claiming in this case?
What I have submitted, on one of these forms that I turned in, I had, crossed out some numbers and, and updated the, that. Oh, my.
Well, let me ask it this way. None of it is for rent.
No,
Okay. And for all of these claims, there are receipts.
yes.
And remind me, how long was she in the unit?
You say again?
How long was she in the unit?
How long she was in the unit? She was in the unit for, from, oh, from 3/23/24 and till October 31st. So about 6 months, give or take.
So, for example, when was the last time
The discussion around repainting and damage becomes a turning point, as the judge challenges whether the issues described are truly beyond normal wear and tear. What seems like a routine claim quickly turns into a technical debate, exposing uncertainty in the plaintiff's justification. The judge's tone sharpens slightly, pushing for clear distinctions that the plaintiff struggles to provide. This moment shifts the energy of the courtroom, as it becomes evident that not all claims will be accepted at face value. Doubt is no longer subtle.
when was the last time the unit was painted before she moved in?
Probably about a year before she moved in.
And then she
But
and then she's there 6 months.
Yeah.
So why is she paying the cost of repainting?
because her kid or her grand son wrote all over the wall crayons. She's not paying for repainting the whole place. She's paying for to go through and touch up all these spots. And you see it in the pictures, all the crayon marks and everything all over the wall.
Yeah, but that was crayon.
Well, crayon or marker, whatever they were using.
Well, there would be a difference in terms of cleaning, wouldn't there?
That's not dirt. That's not normal wear and tear. That's
That's not what I asked you. There would be a difference if it's marker as opposed to crayon.
well, I'm not sure what it was, but I tried cleaning it. It would not clean off. What I had to do is I had to repaint. You know, a lot of those markers say, even after you repaint, they'll bleed back through.
So I'm. Who did this? Um, so I'm trying to figure out. There were items that had to move out. Who moved those items out?
I had to myself and my crew.
So how do I get to 1,090?
Um, oh, you're looking at it, okay. That was, well, let me review it. Well, that was the labor involved to, I had a total of 10.5 hours of moving that stuff out, loading it up, hauling it away, dump fee on that.
So what was the hourly rate you charged?
What we have had agreed to in the lease was $100 per man hour.
Yeah, but what were your actual hours?
The hours, well,
I mean,
probably about 10 hours.
all of the labor in here, was that done by you?
Not me, or some of it was done by me personally, but most of it was my people that work for me.
And they're going to testify as to all of this?
Pardon me?
They're going to testify as to all of this?
I did not plan on having them this thing, but I could, or one of them could. The other one has moved to California. I can provide.
Where were these doors? See, I'm going to tell you right now what I got a problem with. One of the problems is the time it's taking to do these things.
The judge directly confronts the plaintiff over excessive labor charges, particularly the claim of taking nearly 18 hours to install doors. What follows is a firm, almost incredulous response, as the judge dismantles the reasoning with practical knowledge and sharp logic. The plaintiff attempts to defend himself, but the explanation only deepens the skepticism. The exchange becomes intense, with the judge asserting authority and drawing a clear line. This is the defining moment where credibility takes a major hit, and the tone shifts from questioning to outright disbelief.
The time it takes to what?
To do these things.
Okay.
I mean, I got you're charging $100 an hour, which is a little odd to me because if you were to hire somebody, that normally would not be the cost.
Well, it wouldn't. Well, it would be if I.
No, it wouldn't.
If I hire a handyman service to come in and do these repairs, the local handyman companies are charging in the area of 100, 125 per man hour.
But they do it quicker.
I I would not say that they do it quicker.
You're going to tell me it took you almost 18 hours to replace doors?
That's a lot of work, placing a door.
You know, that's a funny thing. Everybody thinks as a judge, I don't do anything. I just go home, crawl under a rock, and I never repair or do anything. If it takes you 18 hours to install 2 doors, you better have reinstalled the frame, had to knock it out, put wood in. There is no way it's going to take 18 hours.
I know that for a fact because there was a door that I had replaced in that building a couple of years prior to that. And I had real specific time that I recorded on that. By the time you go order the door, go back and pick it up, deliver it to the job site.
Paying for the order and pick up at the door?
That door's not going to appear there automatically. How am I going to hang a door if I don't have the door? I've got to go buy it. I've got to order it. Might not.
That's not a labor charge.
It's the cost of doing business. If I came to your house and put a door in, I gotta include the cost of me going to the lumberyard, buying that door, delivering it to
Well,
you.
if it takes you 18 hours to put in a door, you're not coming to my house to do it.
Well,
I'll tell you what, because I'll have that door in by the time you get there.
well,
There's just no way.
to install a door in an existing opening where you've got to cut and double the doors, cut the lock set or the passage set into it, bevel or mortise for the hinges. It's certainly, that's what it takes. That's the amount of time it takes to do that.
Okay. At $100 an hour, but you're not a professional at doing.
I am a professional. I'm a licensed builder. I've been doing this for over 45 years.
And it takes you 18 hours to put in 2 doors.
That's the amount of time to be involved.
Okay. All right. No, you'll just get left to your proofs. Because that is an incredible amount of time to do that. And how were these 20 bulky items taken away?
They were hauled away by truck by a fellow that works for me.
It took 10 hours to get all this stuff out.
That's the amount of time we had in that portion of it.
I don't know what that means.
Well, what are you specifically asking about? The items that she left behind?
Yes.
All right. We had to pull all that out of the house. I had it in the garage for a while. We go on having to load it in the truck, haul it to the dump or the recycle, location.
Well, how long did it take you to get it out of the house?
Well, that was the amount of time I had involved.
How much time did it take you to get it out of the house?
I'd have to double check my specific records on that, but I would suspect it's going to be 2 to 3 man hours to haul this stuff out of the basement, out of each of the bedrooms, and getting it out of the house into the garage.
And then charged again to load it from the garage onto a truck.
Right.
Doesn't it seem to you it would have taken less time if we're charging by time? That if you take it out, put it right on the truck, you save time.
If I have a truck ready to go to the dump, that would make the most sense. But
yes, it would.
But I was gathering stuff up to make sure we had all the debris we needed. I had to figure out how much. It was more than one truck. You know,
maybe you're not understanding what I'm saying. What I'm saying is you're trying to charge for time that seems to me to be extra time based upon the way that you did it.
I put it in the garage.
I heard you.
That was right where you can back the truck up to and then load it compactly into the garage. Once you see
How
what
come when I say something, you try to explain to me like a rationale behind it? I hear what you're saying. I'm just saying you're charging for, you created more work.
no, I disagree.
Okay, but that's the great thing about this. I'm the one making the decision. But you created more work.
By doing what? Putting it
By taking it out, storing it someplace, then coming back and then reloading it. It takes more time than if you had taken it out, put it right on the truck and taken it away.
It's a minimal amount of difference. The garage is right next to where the house and driveway right there, we can back the truck up to. You know, to pack that truck, compactly, you want to see what you've got, what you got to put into that truck. You can't just randomly start throwing stuff in the truck. You'll never have all your stuff in there in an efficient load. I've been doing this kind of work for 50 years and
Not very well if you're doing it this way.
well,
I'm done with you. Don't say a word to me.
all right.
Norman, anything you want to say? Well, hold on a second before we get there. How is the plumbing her fault?
What's the question?
How's the plumbing parts her fault?
Um, uh, they had a bathtub that was backed up. And they were doing something to it and they broke the trap on that and causing a leak. They were trying to get a bathtub to drain and broke that. And I had to go back in and fix a bunch of drywall that got damaged and fix the plumbing that they had from the leak that they caused.
Was there an inventory move-in sheet?
Yes, there was.
What portion of the lease has the $100 in it?
Pardon me?
What portion of the lease has that $100 labor charge? Which I'm not sure is legal, but go ahead.
I gotta think the lease on it's there the portion in that lease that said if there's damages they can repair them, or if not, they agree to hire Stanford Enterprises to take care of the repair.
So in the lease, the tenant agrees to hire your company.
Say again.
In the lease, they can't get somebody of their own choosing to do the repairs.
No, they can't. If there's
Well, what's this about hiring Stanford Enterprises?
well, if they don't fix it, I've got to have my crew go in and do the repairs. If they do damages and walk away.
Where's the $100 thing. It says tenant will pay the company's standard rate. Current rate is service and trip charge of $50 plus $100, right? Per man hour.
Right.
All right. Ms. Norman, you got anything to say on this?
I do. So just kind of going back to how when the case started and that last case that we had the consent order for, he talked about I believe he's talking about number 6, the defendant may be liable for damages. I was
Yes, ma'am.
I was concerned about that and voiced my concerns to you, and you specifically asked him on record if he was waiving rent and monetary damages, and he said he was. His counsel was there with him.
Did somebody provide a transcript of that?
I did submit the flash drive of the video.
Right, but what date was that hearing?
10/22 of 2024.
We're running what? We're running jabs, all right. Pull up our copy. All right, go ahead, Ms. Norman. Well, I'm trying to find the official copy. We didn't pull a transcript, but I mean, I saw what was there, but these days I have to be careful regarding that. But go ahead. What else were you saying?
So I did want to point that out, that he did waive those things. Also, what got us into court was because the property was damaged in the first place. And I did ask the court if I could reopen my case since Mr. Stanford was bringing this back into your court. And at the time you denied it, and there's photos of the damages that were on the property. I'm sorry, I didn't hear you.
Up on move-in.
Correct. And I called the township myself for the inspection, and the house was inhabitable. So there was a lot of things he had to fix, and then he didn't have that certificate of occupancy as well.
The certificate of compliance he didn't have.
Oh, compliance. Okay.
No,
No, he did not. My deposit was $3,500. Let's see. And he's talking about this big plumbing issue. I called him the moment that started leaking. I don't even believe we were in court at that time. And he came there and I asked him to remediate that water, or if he had a shop vac, and he said, "Don't you have a mop?" So that was a whole thing. But I was not trying to fix that. I'm not a plumber. I called him immediately. I'd like to just address quickly the amount of monies he's trying to charge me for.
Hold on a second,
Okay.
Stormy. I now see that. What? How much was the monthly rent? I just got to update myself on that.
The monthly rent was 3,300.
So, in all of your, I'll come back to you in a moment, Ms. Norman.
Okay.
In all of your estimates, there's a $3,500 security deposit, not the $1,050.
That's right. The lease called for 3,500, I believe. She had not paid the full deposit.
So then why did she move in?
Well, she wanted to move in, I gave her a break.
And why wasn't the lease changed to reflect that?
Well, she had agreed, that she was gonna get caught up and pay the difference on that.
By when?
Well, we had,
Is there anything in writing to that effect?
we have, agreements that,
Was there anything in writing to that effect?
don't know that there was some printed things that communications that we had back.
Okay. If you want to play semantics with me, we can play it all day.
Okay.
If you want to play semantics with me, we can play it all day because I bet you I can beat you. Do you have a signed writing indicating anything about that security deposit that's different from what the lease says?
I have records showing what she paid. I don't have a written agreement of what transpired.
So the answer to my question is no, I do not have that.
No.
Were you able to find it?
So Mr. McCurgy was present at that hearing, and he says, we're not claiming money damages for rent. This is only a claim for return of property. I still have much to listen to, but that's what I've got so far.
That was on which case? That was on the first case, correct? I get why he says that, though. All right. No, I may need a transcript of that proceeding then. Prepared.
Okay.
Okay. All right. Miss Norman, I interrupted you. You go ahead. What else did you want to point out?
The deposit, and he's making claims that the furniture, removal of the furniture, he calls the city to have that removed for free. Because when I moved in, there was furniture sitting in the driveway, and he informed me that these bulky items, all you do is call and they remove them for free. So I'm under the impression that that's what happened in this case as well. I did try to call, I did call and talk to Cindy at the township office, but they don't keep records. So
Right.
but I didn't see any receipts in all of the items that he sent me
I
either.
didn't, but
I see these punch something or other, but I couldn't read them. I don't know what that's about.
this property was located, is it in the city or in the township?
No,
In Pittsfield?
it's this.
You didn't have a certificate of occupancy?
The township failed to follow their procedure as far as renewing that.
So the answer to my question is no, you did not.
As the defendant speaks, a critical issue emerges. The property may not have been legally rentable due to missing certification. This revelation flips the narrative, forcing the judge to reconsider the entire situation. Suddenly, the focus shifts from damages to legality, raising the possibility that the plaintiff himself may be at fault. The judge methodically walks through the implications, suggesting that money paid might need to be returned instead. It's a powerful closing stretch, leaving the case on a dramatic note as a trial is set and both sides are left facing serious consequences.
Which means you could not rent.
When she first gave me,
Which means, correct me if I'm wrong, that you could not rent that property.
technically by law,
That's what I deal with.
I
You know, you can call it technicality all you want. That's what I do.
and Your Honor, I don't believe that the failure of the township to do the, what they are
Then
statutory.
you may have a claim against the township, but if you don't have the certificate of compliance, you can't rent it.
And I wasn't aware of that when we signed the lease.
Okay. So how much rent did she pay you? Because if you can't rent it, you can't charge her rent.
I submitted some information on how much she paid for, and I just did that information here. Oh, let's see. Well, she paid $4,000 on 3/21. And it's the C of O was valid at that point in time. Or C, I guess, technically. And again, I don't have that right here in front of me up to date. You need those numbers.
Well, wouldn't it seem to you if you can't charge rent, and you can't rent it at that point in time, that you might owe her money? Or that at least gets offset as against any claim that you have?
Is that question or?
Well, it might
I
be a
didn't-
statement. If I make it a statement, we're done here.
Could you say it again? Because I didn't hear real clearly what you had said.
Monthly rent was about 3,000 something.
3,300.
Okay. If she paid rent to you at a point at which you can't rent the property nor take rent, then wouldn't you owe that back to her?
I don't think the burden should be on me for the failure of the township.
Again, you might have a claim against the township, but you don't have a claim against her.
Well, I think I do.
Okay. All right, then you keep thinking that. Here's what we're gonna do. Ms. Norman, you're not intending on being out this way anytime soon, are you?
I can be. I was going to be there today. I just was in the hospital. I have influenza A.
Okay. Give me a trial date. I want to clear it. I don't know if this is gonna take all that long.
April 20.
April 20th,
28.
28th. Okay.
Judge Simpson.
Yes, ma'am.
Just so you know, I paid him. It's in the case that I filed before, around $15,000. And all the receipt, all my money orders are there. Everything is there. But just so you know.
In the previous matter, right?
Yes.
Yeah, I'm not, I know that based upon my memory of the previous case, you paid the money. That's not my issue. My issue is monies that you paid that maybe you shouldn't have paid. And what I'm suggesting to Mr. Stanford is that that may offset any claim he has.
Okay.
So what I'm going to do is 428. I'm going to set a non-jury trial. I'll need the parties here in person. I was going to set it for April 28th, 2026 at 9 a.m. Is that right?
Yes.
Will that work for the parties?
Yeah.
For me.
All right. And then we'll decide. Pardon?
What was that date again?
April 28th.
April 28th. At
9 a.m. And what I might suggest, Mr. Stanford, is that you look at how much she paid during the time at which your property did not have a COC or temporary COC, and determine whether or not you want to head forward with this case, because it may offset anything that you might be entitled.
Understand.
All right. Anything else from either side?
No.
Oh, thank you.
All right. Thank you. Are they ready on this?
My understanding is yes.
Hasim Yasmin versus Shannon Somerville.